Hey again, David Phillips, attorney. The question comes up quite often, can I put a car title loan in my bankruptcy case? And the answer to that question is yes, you can. Comes up quite often, as a matter of fact. And depending on which chapter of the bankruptcy you're filing, we would be able to help you determine if you could keep the vehicle or not. In a Chapter 7 case, if you're way behind on your title loan payments when you file the Chapter 7, it's possible that the title loan company would want the car in the event of the bankruptcy filing, and you might very well lose it back to the company. That doesn't happen maybe as often as you would think, because a lot of times the vehicles are not going to be worth enough for the title loan company to want to take possession of the vehicle. They'd far rather have your money. So even if you're behind, you might be able to work something out, even though they do have a valid lien against the vehicle, and you can't just get rid of the debt that you owe them and then keep the car. The lien, if it was done properly, is against the actual title, therefore the name title loan. If you're filing a Chapter 13, you can certainly deal with title loan company type creditors, just like you would if it were General Motors or Ford Motor Credit, Chrysler Financial, any of the big car company credit financiers. Usually you're going to be looking at much higher interest rates on these little title loan companies, and Chapter 13 offers you the opportunity to probably get that interest rate lowered substantially from where it was when you originally got the loan. Another advantage in 13 would be if you're way behind on the title loan, you would be able to still keep the car and hopefully make those payments up in a payment plan, and so it's a good deal. The title loan company is getting their money. It's just that, again, the interest rate may be lowered quite a bit from what it was in the contract. Usually, or almost always, I should say, title loans are not going to be the original financer, obviously. Therefore, these loans would be able to be crammed down. You could owe several $1,000s, say, on the title loan, and the vehicle might not be worth anywhere near that. And in a Chapter 13 plan, we would be looking at the actual value of the vehicle versus what the debt may actually be to the title loan company. If you completed your Chapter 13 plan, you would then receive the title back from the loan company, and it would be no different again than if you were financing with a traditional bank or so forth. So in short, the title loan company, even though they generally are dealing with a lower tier of financing versus the big companies that we're all familiar with, their loans are treated the same in Chapter 13 plans, and for that matter, if you're filing Chapter 7, the same issues would be there. Are you current on the title loan, and do you want to keep it? In the Chapter 7 context, I might say, if the car is no longer of any value to you, maybe it's in disrepair, you don't want it anymore, you could discharge that debt in Chapter 7 and simply surrender the vehicle back to the title loan company if they would come take it. Hope that's some good information for you about title loans. There certainly can be put in a bankruptcy filing, and it occurs every day. Please give us a call if we can give you more information regarding title loans and bankruptcy. If you prefer to contact us by email, go to phillipsbankruptcy.com, go to the contact section, shoot me an email, and we'll try to get you a response very promptly. Thanks for watching the video.